experiences can be drawn from those places. In the Kenyan situation, drawing from the past, informed by the present, and focusing on the future, the 2010 Constitution has set up a framework which returns Kenya to the path of democratization. Parliament cannot be used to pass amendments to the Constitution in the manner it did before 2010 because of the current inbuilt mechanisms and safeguards, as well as the complex and elaborate procedures in the Constitution itself. The situation the Supreme Court of India was addressing in Kesavananda is unique to India based on the specific provisions of the Indian Constitution, Article 368 to be exact, their experience, and also based on their history generally. Therefore, in relying on Kesavananda, hook, line, and sinker to address the peculiar circumstances of Kenya, the superior courts below ought to have exercised caution and followed the guidelines repeatedly emphasized by this court in various cases, Judges and Magistrates Vetting Board and the Rai case. Courts ought to avoid mechanistic approaches to president because it is inappropriate to pick a president all over the world simply because they appear to provide an answer to a matter at hand. Each of those presidents has its place in the jurisprudence of its own country of origin. There was justification to rely on Kesavananda in interpreting Section 47 of the former Constitution in the Njoya case because at the time our constitutional framework was more or less similar to Article 368 of the Indian Constitution in the sense that the power to amend the Constitution reposed in Parliament and Parliament alone. But this is no longer the case in Kenya. Throughout the constitutional making process, from the Bomas draft, the Ouko draft, the revised harmonized draft, and the proposed draft constitution, it has been made abundantly clear that since the Constitution embodies the will and aspirations of the people, they must be central to its amendment, and that there ought to be a balance to have a Constitution that is flexible enough for posterity and unforeseen needs, but rigid enough to prevent the abusive hyper-amendments of yesteryears. This balance was achieved by clear, unambiguous, and distinct tiered or multi-stage design model codified in Chapter 16, applying different procedures of amendment for different provisions of the Constitution. Specifically, amendment process of any matters in Article 255(1) is complex and onerous. It requires support of 1 million voters, requires the promoters to draft a bill, which then must be verified by the IEBC, and finally, and approval by the county assemblies and parliament, meeting a certain threshold, and finally ratified in a referendum. Attempts to utilize both parliamentary